Good evening and welcome to Blueprint Explosive Exclusive. I'm Madhavdas G. Now, in a dramatic turn in one of the country's most politically charged legal battles, the Supreme Court has openly raised questions over the judgment that denied bail to Umar, Khalid and Sharjeel Imam in the Delhi riots conspiracy case. While hearing a separate narco-terror bail matter today, the top court has warned against prolonged incarceration under anti-terror laws and strongly reiterated that constitutional courts cannot allow UAPA to become a tool for indefinite imprisonment without trial. At the heart of the controversy now is a central question. Can people accused under UAPA be kept behind bars for years without trial simply because the law makes bail difficult? Now, this is the same Supreme Court that in January this year denied bail to Umar, Khalid and Sharjeel Imam in the Delhi riots larger conspiracy case. That judgment had relied heavily on the strict bail conditions under the UAPA. But today, while granting bail to a Jammu and Kashmir accused, jailed for more than 6 years in a narco-terror case, another Supreme Court bench virtually questioned that approach. Justice Ujjal Bhoyan and Justice B.V. Nagaratna said that courts cannot allow UAPA to become a mechanism for endless imprisonment without trial. The bench specifically referred to the Gulfisha Fatima judgment, the very same judgment linked to the denial of bail to Umar, Khalid and Sharjeel Imam, and said that it had serious reservations about that ruling. What exactly was it that the Supreme Court has said? Let's take a closer look. The first observation is that even under UAPA, bail is the rule. They've also gone on to talk about how Section 43D5 is subject to Article 21 of the Constitution. They further added that UAPA can't justify indefinite incarceration, further adding that serious charges need faster trials and that pre-trial jail cannot turn punitive. Very important observation. They've said that a long delay in the trial can justify bail. Very, very stringent observations. Now, the court has said that the earlier judgment failed to properly apply the landmark K.A. Najib verdict of 2021, where a larger 3-judge bench had clearly ruled that prolonged delay in trial itself can become grounds for bail under UAPA. Let me take you through what does the K.A. Najib verdict specifically cite. They've said that the primacy of Article 21 is important. Gross delay violates Article 21. Speedy trial is a fundamental right under the K.A. Najib verdict. They further added that right to life includes timely justice, further adding that 43D5 is not absolute when it comes to the act and that UAPA cannot override liberty, and therefore prolonged trial is equal to a ground for bail. The language used by the Supreme Court today was unusually sharp. The court has warned that if judges continue to mechanically deny bail under UAPA because allegations appear quote-unquote prima facie true, then under trial detention itself begins to look like punishment before conviction. Justice Bhoyan went further, warning that smaller benches of the Supreme Court itself were against warning the smaller benches against weakening judgments that are delivered by larger benches. Now, in a significant remark, the court has said that no smaller bench can, and to quote, dilute, circumvent or disregard binding law laid down by a larger bench. Now, that observation is being read as a direct institutional pushback against the earlier bail denial ruling. The Supreme Court has not directly granted relief to Umar, Khalid or Sharjeel Imam, but its observations have unmistakably reopened the legal debate around prolonged incarceration under the UAPA. The court's remarks now raise major questions over how anti-terror bail provisions are being interpreted and whether constitutional protections are being eroded through endless pre-trial detention. Listen in to the political reactions coming in.
There is no reason for any politics on this. The judgment is still not out. However, those from the certain vested interest lobbies who are sort of celebrating on this would have to also bear in mind that the people in these cases are those who have been charged with very, very heinous crimes, particularly acting against the interests and security of the state, which may be in terms of narco-terrorism, maybe in the terms of terrorism, or in the other cases of Delhi riots.
सरकार का उन पे विशेष दबाव रहा होगा और सरकार नहीं चाहती होगी कि इनकी बेल हो, तो सरकार के नज़दीकी बेंच वाले जो जज साहब होंगे उन्होंने बेल नहीं करी। ये बिल्कुल सीधा सा फार्मूला है, क्योंकि सरकार को नैरेटिव चलाना है निश्चित तौर पे इस देश में कुछ ऐसे विचारधारा के लोग हैं जो एक धर्म को लोगों को बदनाम करने की बात करते हैं।
अब धर्म देखकर अगर उसकी बेल को रिजेक्ट करेंगे तो ये बेहद शर्मनाक है। ये तो संविधान की मूल भावना के खिलाफ है। ठीक है, जब आप अभी तक ट्रायल शुरू नहीं कर पा रहे, इसका मतलब कोई सफिशिएंट जो इनक्रिमिनेटिंग एविडेंस रिकॉर्ड पे अवेलेबल नहीं है। अगर अवेलेबल होते तो अब तक ट्रायल शुरू हो चुका होता। अब आपने फंसा दिया सब। ये भारतीय जनता पार्टी की गुंडागर्दी और तानाशाही का नतीजा है कि वो चुन चुन के एक विशेष धर्म के लोगों को, विशेष जाति के लोगों को प्रताड़ित कर रही है, उन पे झूठे केस बना रही है, जेल में डाल रही है।
Let's take this across to our guest. Joining us with us is Dr. Kaushal Mishra, spokesperson of BJP, Advocate Harsh Dahia as a political analyst joining us. We also have Syed Asadavas, political analyst, and Sanjay Hegde, senior advocate, also joins us on the show. But let me start first and foremost with Dr. Kaushal Mishra. Dr. Kaushal Mishra, the courts are questioning the own judgment that has been passed by a relatively smaller bench, saying that they have not followed the precedent that was set in an earlier judgment of the K. Najib case. What would you say? Because while the courts have not granted any relief, the position of the previous judgment that came out in January now comes under question.
Madhav, it is an intra-departmental observation passed by the same department. It is a total matter of independence of judiciary. They are passing their remarks against their own judges. So, what we should say, they are independent to give their observation for themselves also. So I can't say about that. But you cannot compare the apple with oranges and oranges with apple. I am saying this because in the last judgment in the January 2026, the same Supreme Court says that Gulfisa, Fatima and some Haider given the bail, but other two, Sharjeel Imam and Umar Khalid, denied the bail on the ground that they qualified the quantitatively different footing. Their position in the case was they are the main conspirator, so they cannot be compared with anybody. And if we are going to the pendency of bail, I have seen that around 500,000 Indian behind the bar, 74% is still awaiting a trial. Why everybody is going behind this UAPA? It is the Supreme Court itself says over 70% of the Indian prisoners have not yet found guilty. Supreme Court, this is observation passed by the Supreme Court. So here nothing but it is intra-departmental observation passed by one judge for the other bench. Government should not.
Okay, Sanjay Hegde, I would like Sanjay Hegde to respond to that. Sanjay Hegde, this is an intra-departmental, observation of one judge for another judge, and therefore, of course, one should not read too much into it. In fact, a BJP spokesman who you know heard earlier also has said that wait for the final judgment.
See, firstly, we do not have departments in the Supreme Court. The Supreme Court speaks through various benches. It is a polyvocal court, and if a doctrine is laid down by a larger bench, a smaller bench is bound to follow it. Now, this bench of two judges has differed with another bench of two judges in its application of the doctrine laid down by three judges in Najib. So this bench feels that the earlier judgment in Gulfisha, insofar as it denied bail to Sharjeel as well as Umar Khalid, possibly was a wrong application of the doctrine. This happens all the time. The law is constantly being tested by various benches of the courts based upon fact circumstances. Therefore, today what the court has again reiterated is a policeman can't just accuse you under UAPA and throw away the key and say we will not hold a trial. If a trial is unnecessarily delayed or prolonged, then constitutional courts are bound under the Najib judgment to grant bail, notwithstanding the fact that it is a UAPA allegation. Let's just look at it in terms of basic fairness. If, God forbid, you or I were to be accused of something, We have a right to a speedy trial. The prosecution and the government can't say, oh, we will have a trial in God's good time, but in the meanwhile, you will stay indefinitely in jail. That is simply not fair.
Okay.
And the court has said it, has reiterated it, that notwithstanding what is the offense.
Right.
Oh, you say UAPA, you say NDPS, this, that, and the other. People are entitled to be granted bail if the system...
Okay. The larger question is this. I think it boils down to that last sentence that you just spoke. And in fact, let me bring in Advocate Harsh Daya. Bail is the norm and jail is the exception. Ultimately, that's what the court is relying on. And they are saying that, you know, an under trial person, extended periods in jail, that under trial portion cannot become the punitive aspect of it. That's the observation coming in from the Supreme Court. Your response?
You know, Madhav, first I would like to talk about the political angle that is being given to this particular matter. You know, what it makes me feel like is that life of Hindus in this country is very cheap and anyone can go on stage and challenge the integrity of India. And, you know, the media trial would be done and they would be presented as...
No, that's not fair. Advocate Harsh Daya, that's not fair. When the court did not grant bail, also we debated it with this much vigor only on the same channel.
No,
now that the court is going on,
Madhav,
you know, it is not correct for you to say or interpret this as, you know, Hindus or this. The point is, this is a legally, this is a politically sensitive case. I'll grant you that. But, you know, to link it to the entire aspect of Hindus or Muslims, etc., I don't think that is correct. It is a case which is testing the limits of what the law is in this country. Let's admit that.
53 people died in those riots, and to say that, you know, these people should be treated as just normal criminals, that is not done. And, you know, if you look at the January 5 order as well, it has clearly stated that they can file a fresh bail application after the protected witnesses are examined. And, you know, if you go through the whole trial record and the records of the Delhi High Court and Supreme Court judgments so far, you will realize that there is a deliberate delay in trial by the defense to get them bail, because they understand one particular fact, that getting them bail you know, in normal circumstances is going to be next to impossible because of the seriousness of the crime and evidence on record. And if you just examine the order of Delhi High Court of Justice Naveen Chawla and Justice Shalinder Kaur, the 4 stages, in your previous debate as well, I have demonstrated how these people in 4 stages have implemented these riots. In the stage 1 of leading
so that's
up to
part of the
riot,
investigation. That's part of the investigation. I grant you that. But the point is, and nobody is taking it from the criminality. If they are criminals, if there is enough evidence to prosecute them, no one's going to short circuit or second guess that process. The simple question is about the larger issue of bail when it comes to UAPA. But you have made an important point, and I'm going to bring in Syed Asad Abbas on this. Syed Asad Abbas, Harsh Daya says that it is the accused themselves who are delaying the process by prolonging it, by dragging it further through the various adjournments and other aspects, legally speaking, and therefore they have brought this situation upon themselves. Please respond to the advocate.
I absolutely do not agree to my dear friend Harsh. The fact of the matter is, Supreme Court in his observation has made with Justice P.V. Nagratna Ji and Justice Ujjal Bhuyan that such serious cases must have speedy trials, without which this will be an indefinite incarceration. So therefore, when there is indefinite incarceration, questions are raised on even UAPA laws. Let us understand that it is made it clear that bail here needs to be given. Let us also understand that the number of years without even a trial that Khalid has gone through, a man who's been fighting for years indefinitely, the trial has not even started and years he's inside the jail. For what reason? Bail is rule, jail is exception, and that is made it clear even keeping UAPA in mind. The fact of the matter, we need to understand that Supreme Court is supreme for a reason. And today's judgment, today's observation has made it very clear. So therefore, I believe that in the years to come now, or even in this case especially, there needs to be a speedy trial. It is the need of the hour.
Okay. There needs to be a speedy trial. Kaushan Mishra, come in on that. Why has that not happened in this case? Because, you know, the point being made over here is this, that this prima facie aspect can go on for a certain amount of time. Beyond 5 years, 6 years, or a longer time period, you know, this sort of is tantamount to misuse of the provision is the suggestion coming in.
Madhav, I think FIR was lodged in a provision of UAPA, which is an act passed by this parliament only, and that has got a very stringent and strict condition of the bail. And the Supreme Court can consider, so I cannot comment on the wisdom of the Supreme Court, but Hegle sir was saying something, sir, if the bail is not granted and if you feel that this FIR was filed against the wrong section in UAPA, why not go and challenge the section of FIR, why it was filed under the UAPA, why not under other section? Because it is a case of terrorism. It is a case of.
I want quick response from Sanjay Hegde. Sanjay Hegde, quick response. The act itself is so heinous that it merits the application of UAPA. Please respond to Kaushal Kant Mishra. And that is why there is specific provision.
Listen, that's entirely a call for the investigating agency. Tomorrow there may be a different government. A different government may say that, look, all of you people who have been involved in lynching are terrorists. We shall prosecute under UAPA. Then we will not conduct trials at all for 6 years, 7 years. Would that be fair? The law standard has to be the same. Jail is neither Hindu nor Muslim.
Okay,
it is about.
Yeah, I'm sorry, there's some breaking news coming in. Dr. Kaushal Kant Mishra, Harsh Daya, Syed Asad Abbas and Sanjay Hegde, we'll have to leave it there. Big update coming in at the moment. Flight operations in Mumbai's Chhatrapati Shivaji Maharaj International Airport face major disruption this afternoon after employees of AISL, the government-owned ground handling agencies servicing Air India Express and several foreign airlines, the employees launched an unannounced industrial action or a strike. This disruption affected key airport functions, including baggage handling, boarding and aircraft turnaround operations, leading to delays for multiple flights. Let's take this across to my colleague Shefali. Shefali, how long did this action go on, this strike go on? Was it a sudden strike? Was a notice given? And we believe that it has still impacted to some extent the operations at the Mumbai airport. Take us through the details.
Right, Madhav. We know that the ground handling staff had some issue with AIASL, which is Air India Airport Service Limited, and they had some issues with their demand. Their demands were permanent place in there, as they are working contractually. They wanted a permanent job, and more than that, they wanted a hike in their salary. But today it was a silent morcha that carried out this protest, and it was a flash protest that happened around 11 a.m. in the morning, and it went around for 2 hours, after which the officials of AIASL asked for their demands, to which the ground handling staff gave the letter to them, and then they also been assured that their demands will be looked into. But if we talk about Mumbai airport,
yeah, so that's a big update coming in. In fact, the airline saying that airport teams are working to restore normalcy and minimize inconvenience to passengers, while contingency measures have also been activated to manage the disruption. Thanks so much for the quick update there, Shefali. More updates coming in at the moment. In fact, this is a massive revelation that's now emerging in the widening NEET paper leak investigation. Sources telling Times Now that investigators are probing the role of retired Professor P.V. Kulkarni, who allegedly had access to all NEET question papers as the official Marathi translator for the examination process and had been part of the UG NEET examination panel since 2019. According to sources, the first set of question papers was allegedly handed over to Shivraj Motegaonkar, a Latur-based coaching institute operator known to Kulkarni for several years. Let's take this across to my colleague Kritika and Bhavtosh, who's getting us this information. Very, very significant, Kritika, that the modus operandi of how Kulkarni roped in Manisha Wagmare, asked her to bring in selected students for coaching sessions conducted at his residence, and also the role of Manisha Mandhare, a botany professor linked to the NAT examination panel, who's also allegedly helping to expand the network in this case, is now coming out of the open. Kritika.
Well,
Well, absolutely, Madhav. In fact, earlier also we reported on the huge money trail as well. 20 to 25 lakhs were paid, in fact, by parents in order to access parts of these question papers as well. And now we are seeing that the CBI is, in fact, honing on to the prime accused as well. Now, professors linked with the NTA are now coming under the lens. Of course, the link is now being probed in Pune, so there are multiple coaching centers as well that are under the scanner. The way in which it all spread to the Telegram group was also first, in fact, disclosed by CBI. That made it very clear, even in their initial remand note as well, that the role of, in fact, NTA as far as officials.
Okay, Kritika, we'll come back for more updates on this crucial aspect, but there's some more breaking news coming in. The Parliamentary Standing Committee on Education has summoned NTA chairperson and senior officials of the Ministry of Education on the 21st of May. This meeting will review the NEET UG 2026 paper leak case and exam reforms. The committee will discuss progress on the investigation into the alleged paper leak in the NEET UG exam cancelled on the 3rd of May 2026. All right, that's a Parliamentary Standing Committee meeting that we're certainly going to be watching out for the moment, slipping into a quick break.